Good evening, all. Few years back, we never could have imagined that a virtual event would be possible with such a large gathering. Likewise, we never could have imagined a compensation for a motor accident claims shall be dispersed to the victim family within 10 days from the date of accident. It's a milestone in the Indian judicial system. I promise by end of this session, each stakeholders and participants will have an insight how they can contribute the best for the social cause. Now I would like to call upon Mr. M.N. Sharma, the Secretary General, GI Council, for the welcome address. Having 38 years of industry experience, Mr. Sharma is a former CMD of United India Insurance, former MD CEO Ken India Assurance Nairobi, former MD and CEO Health Insurance TPA of India, now holding the good office of General Insurance Council as a Secretary General. Sir, I would call upon you for the welcome address. Over to you, sir.
Thank you, Mr. Durairaj. And good afternoon to you all, ladies and gentlemen. It's a great pleasure on my part to welcome you all to this commemoration ceremony that is being hosted by the General Insurance Council and the Bajaj Allianz General Insurance Company under the aegis of the Delhi State Legal Services Authority. This, as Mr. Durairaj has already explained, is a kind of a small achievement, a humble achievement that we are going to talk about, how we have been able to settle a motor third-party accident claim within a period of 10 days. There has been a tremendous effort on the part of the two eminent judges that we have here today on the panel of discussion here as our honorable guests. They are the people who Mr. Raveendran, the Supreme Court Honorable Justice of the Supreme Court, he has laid the seed for this in a case called Jai Prakash versus National Insurance. In his judgment, when he has created a kind of a background for achieving this a very quick and timely settlement of the motor third-party claims. He has laid down the basic criteria by way of a detailed accident report, what all things to come in and all that. And that has been carried forward by Honorable Justice Midha of the Delhi High Court by way of in several stages over a long period. And the full details of this will be coming to you from the directly from the mouth of Shri Midha himself. And of course, at the end of it, by the end of this panel discussion, you will be fully aware of what we are talking about and how we have been able to reach this stage from the current, from the previous stage of very delayed settlements to this current stage of a very fast settlement. Of course, this is a first milestone that has been reached, and in itself, it's a history that is created. But now it is up to us to take it forward and then implement this. So what was supposed to be an impossible thing has been made possible thanks to the great effort of these two legal luminaries, the judges, and with their help and guidance, things are moving faster. I have great pleasure in welcoming Honorable Mr. Justice Raveendran sir, R.V. Raveendran sir, the former Supreme Court judge, and then our Honorable Mr. Judge, our Mr. J.R. Midha, sir, and these two are the main primary speakers and who will be communicating their views and then their objectives and then how they would like the things to go be taken forward to in due course. And of course, I have great pleasure in inviting the other panelists in this meeting today. They are Madam Mrs. T.L. Alamelu, Member Non-Life in IRDA, and Shri Atul Sahai, CMD, New India Assurance Company Limited. He is also the GIPSA, General Insurance Public Sector Association Chairman, and also the Chairman of the General Insurance Council. I have great pleasure in also welcoming Shri Kamaljit Arora, Secretary, DSLSA, that is Delhi State Legal Services Authority, Shri S.S. Rathi, Additional District and Sessions Judge of Delhi, Shri Sanjay, Special Commissioner at Delhi Police, Shri Tapan Singhal, CEO of Bajaj Allianz General Insurance Company. Mr. Tapan Singhal's company, Bajaj Allianz, that is this company that has settled this claim in 10 days. And we have Shri Patanjali Dev Nair, Regional Advisor of Asia Pacific region of the World Health Organization. In addition, we have also invited as participants, these are the above were the speakers, whereas we have invited a lot of participants that included the Chief Justices of various high courts, the justices from various courts, magistrates, presiding officers of various tribunals, motor accidents claims tribunals, and the entire legal fraternity. Then we are also happy to have invited Department of Financial Services, Ministry of Finance, IRDAI, then the Judicial Academies, National Insurance Academy, Pune, and the Insurance Institute of India, Mumbai. We have the CEOs and senior affiliate life insurance companies that are participating in today's program. And then we have the legal heads of the various insurance companies who carry the responsibility of ensuring the timely settlement of legal claims as per the public. The expectations of the public is going to be fanned up now. So now we have to meet that as a challenge. And then these are the guys doing this challenge on their heads. Then we have the representatives of the media, that is from both the print and electronic media. And I extend a very warm welcome to them all. And friends, this case that we were talking about is the case of one Munshi Lalji, who passed away in a road accident in Delhi. He is a Delhi Panchari. He is an employee of the Delhi police and working as constable on the fateful night of 1st May. And he was mowed down by a speeding vehicle. And his family, Mrs. Vimla Devi, Mr. Shakti Singh, are also participating in today's, we invited them to be part of this meeting. We take this opportunity to convey our condolences to them. We cannot bring back a person who is dead, but the insurance industry endeavors to pay due compensation. And in this particular case, we carry the satisfaction of having got this compensation to them in a very speedy manner as is possible within the time. And credit goes to them also, having accepted this offer and then having made this settlement possible. Thanks a lot. I welcome you all. Namaskar. And I hand over this to mic to Mr. Durai Raj to take it forward. You are on mute.
Thank you very much, sir, for the wonderful address. We are sure this evening is going to be a wonderful evening for us, of the senior legal persons here. Now I would like to call upon Sri Surinder S. Rathi, Additional District and Sessions Judge, Delhi. He is a senior officer of the Delhi Higher Judicial Service, has served as a Registrar of Supreme Court of India and Delhi High Court, as a Director NALSA, also served as a member of E-Committee and Artificial Intelligence Committee for the Supreme Court. Has keen interest in legal research and development of law, has led the drafting of Women Victim Protection Scheme, Vulnerable Witness Depositions Guidelines, Commercial Courts Rules, and many more, and led the drafting of the Fast DAR SOP. Now he will be giving us a bird's eye view about this program. Rathi sir, over to you.
Thank you, Mr. Durai Raj. Thank you, Mr. Sharma. My greetings to my Lord Justice Raveendran, my Lord Justice Midha, the distinguished panelists, and all the esteemed participants. I had the opportunity, do I have the permission to share the screen? This is the small presentation. So today we'll be sharing a small presentation which will be an introduction to the Fast DAR, which is DAR is detailed accident report as we understand. And it's a scheme which is designed for arriving at amicable settlement in a time-bound manner within 10 days of the accident. As we understand, when we talk of accident, we are aware that, as they say, that extraordinary circumstances warrants extraordinary measures. The road safety and the motor accident scenario in the country is, to say the least, very problematic. The word extraordinary doesn't suffice. Rather, the situation has become precarious. And with few slides, I would like to share this with you. The fact that India is world capital for road accidents, because India tops in road accidents in the country. Even though we have only 1% of the world's motorized vehicles, but still we account for 11% of the total accidents which happens globally, which is a huge number. We as a nation accounts for 4.5 lakh road crashes per annum, which leave 1.5 lakh dead and 4.5 lakh crippled annually. Now, this translates into 45 road crashes every hour, and every 4 minutes, one person dies on Indian roads and 12 are injured, which sums up to 400 deaths a day. And please also be mindful of the fact that every road accident leads to a dual remedy. One is because all these accidents are cognizable offenses. So FIRs are registered, which means 4.5 lakh FIRs and 4.5 lakh motor accident claims, which adds to 9 lakh litigations to the kitty of already overbulging Indian dependency in the Indian judicial courts. Now, in the last 10 years, 13 lakh people have died on Indian roads and 50 lakh. Now, according to the data available on the MORTH site, 76.2% of the people who die in our working age, which is 18 to 45. Now, this is not only a human loss of a loved family member, it is also loss of an earning member of the family. And the whole family comes, the whole day-to-day sustenance comes to a stand. And there is an estimation by the MORTH that each death is costing 91.16 lakhs to the nation. Now, according to 2019 World Bank accidents, 4.5 lakhs accidents annually, our country is spending 12.9 lakh crore rupees, which is 7.5% of our GDPs. It's a huge, huge number, which can and due care can be curtailed. And as aptly referred to by Shri Nitin Gadkari, Minister for Road Surface and Transport and Highway, the road accident scenario in the country is more dangerous than even we have been losing our citizens on road because of this. Now, if we compare our position worldwide, I'm sharing a heat map of the world. The darker shows that per lakh population, the fatalities which are happening on the road. So you can see our country is close to Africa and Latin America nations, and then there's a lot which needs to be done. Now, as far as the law is concerned, I'll just give a small recap. The motor accident, the compensation part is taken care by the Motor Vehicles Act 1988. Chapter 10 pertains to liability without fault. 11 pertains to insurance of vehicles for a third party. And the most important, Chapter 12 provides for establishment of the claims tribunal. States are obliged under Section 165 to establish one or more motor accident claims tribunals to decide and adjudicate these petitions. And High Court under Section 173 has been given power to decide the appeals. Now, as far as pendency is concerned, Delhi is, again, we have all the experience that our roads are far from safe. Delhi has a pendency of 18,000 plus motor accident claim petitions. And I can assure you that this 18,000 is, despite the DAR which is being functional in Delhi for last more than 10 years, that this pendency has been brought down to this figure. Otherwise, it would have been multiples of 3 and 4. As per NJDG data, 9 lakh plus petitions are pending, and they constitute 11.65% of all pending civil cases, meaning thereby every 10th case in our country, civil suit, is a motor accident claim petition. Now, this is very important here because as we were discussing that when somebody, an earning member of a family dies, the first thing is that the monthly income goes, the medical expenditures are incurred, even if it's there's an injury and other things. The school fees, the rents, the other day-to-day sustenance costs, everything takes a toll. Now, if the motor accident claim petition is filed, which is not a system-generated petition as it is happening in Delhi, we will come to it later point. When a petition is filed before a tribunal, if a settlement is arrived at by using of ADR methodology by mediation and lok adalat, it takes around 1 year. But if the decision is sought from the tribunal by way of trial, it takes 5 to 7 years. Then it's an appealable order. More often than not, the appeals are filed by the losing party, which takes 2 to 3 years in the High Court. And then another challenge before Honorable Supreme Court, it takes another 2 to 3 years. So meaning thereby, when the actual payment is received by the family, 10 to 12 years have passed, and the immediate sustenance has taken a toll. The family members, they have to discontinue education, and a lot of complexities arise in the family, and the timely decision and the timely disbursement of payment, as we were able to do through this FastDAR, is the only key. Now, the development of law is something which we are here to cherish and share with you all. And the condition which was prevalent in the late 2008 and 9, it pained my Lord Justice Midha, and my Lord Justice, with his experience at the bar and the bench, has drafted a claims tribunal agreed procedure in 2009. This was introduced for the first time in Delhi judiciary, and it was received very well by Delhi police and all the stakeholders and duty holders. And instead of, as I shared, 5 to 7 years, this provides for disposal of cases on merits between 90 and 120 days. Now, this was adopted by the Honorable Supreme Court through the Aegis of my Lord Justice Raveendran in Jayaprakash versus National Insurance, and it was further made mandatory in the to all the states and union territories of India by a specific order of Honorable Supreme Court of India. Now, the development in the claims tribunal procedure, I can share with you from 2009 when it was introduced, 2016 it was mandated in all the states. Now, my Lord Justice Midha was not satisfied by even 90 to 120 days. My Lord gave us a challenge that why not decide a case in 30 days. So we started working on those modalities, but the better part of 2020, we were all struck by the pandemic, so things could not move as fast as they should have. So on 8th of January, my Lord Justice Midha constituted a committee for implementation of MSCT and DAR, and also modified the DAR, because we had a meeting with all the DGPs of the states and other stakeholders of the states as to why they are not in a position to adopt. So it was said that the DAR is very complicated and it needs to be modified and simplified. So this new modified DAR was given to us by my Lord Justice Midha. And on 2nd of April, a specific, another challenge, the bar was raised by Justice Midha, that why not settle a case within 10 days. And as my Lord's words, 13वीं से पहले payment हम उनको दिला सकते हैं, so it will be a historic thing. And guided by my Lord Justice Midha, we had drafted this FastDAR procedure and the SOP with all the stakeholders, and that unfortunate case we'll discuss in next few slides came before us rather on the very first day when this pilot was started. Now, FastDAR SOP, I'll just give a sneak peek as to what kind of cases are covered in the FastDAR. We have a 5 preconditions which are required for covering a case for FastDAR for awarding and settlement within 10 days. The first is that it has to be a fatal accident caused by a rash and negligent act of the driver. Second is the driver should have a valid license. The third is that the offending vehicle is validly insured at the time of accident. In case it's a commercial vehicle, it should have a valid permit and fitness. And there should be no violation of the insurance policy, like we understand drunken driving or a child who is unauthorized to drive was driving. Now, once we scan through these, through each and every case which we have planned now of all fatal accidents in Delhi, if we find these five conditions satisfied, then we can consider that under the FastDAR, because there are no factual disputes, then we can settle these cases without going to the rigors of the trial. Now, these are the stakeholders which were taken into confidence: the police, the General Insurance Council, the companies, medical authorities, MORTH, legal services, the tribunal. Everybody cooperated when we arrived at this settlement, this SOP. Now the timelines which were provided is because 10 days is a too short period. So we divided by the ratio of 5:3:2. We gave, once these 5 conditions are found to be available, we gave 5 days to the police to do the specific, fill up the specific format and share it with the tribunal and the insurance company. Insurance company starts its investigation from the day 1 and is given additional 3 days to make an offer, and the last 2 days are given to tribunal for holding conciliation and pre-lok adalat sitting before passing an award before a special lok adalat. So these are specific duties given. As I shared, Delhi police will conduct the verification done of the documents, and we are also focusing on the fact that I'll in the later part of this presentation share as to how we are going to use technology in getting these verifications done. In the caption case which we'll be discussing today, with the driver and the deceased were of Delhi, but we can understand that they can be from different states, and it may not be possible in all the cases to do it in 10 days. GIC also very positively reacted to this, and they said they'll be establishing a call center which is 24/7, so that everything which relates to the insurance company is coordinated through a centralized agency. The insurance companies came forward like the very good gesture by Bajaj Allianz. It was but for their cooperation and the fortitude, it would not have been possible to get this settlement done the way it was done. The medical authorities, we discussed with Delhi, the government of Delhi, NCT of Delhi was again very supportive. They said in all the fatal cases, they assured us that within 48 hours, postmortem report and will be prepared and shared with the IO for completing the FastDAR. Transport Authority cooperated that once they are given an information, in case the data is not available in Vahan and Sarthi, they will do the verification part within 24 hours. Legal services on its part assured to provide legal services panel lawyers for assisting the victim's family to during the negotiations with the insurance company in the pre-lok adalat sittings and then the lok adalat sittings. And finally, the tribunal in this instant case, Mr. Harjot Singh Bhalla, who was presiding officer of the Lok Adalat and the MECT in New Delhi district, he did wonderful job. Mr. Manoj Nagpal, who was earlier presiding officer in New Delhi, they all joined hands and cooperated and arrived at this settlement. Now, this is a small, we can say on 1st of May, the chronology of events, the pilot was started. On 4th of May, we got to know about this. So under the directions of my Lord Justice Midha, I was convening this committee on the fast track. When the moment we prepared the SSOP, this first unfortunate case which happened on the dead of night of at 3:45 a.m. In the night, it came that a policeman died as a COVID warrior on duty. A man dozed off on in his car, and then he rammed into the police picket. And then Mr. Rajesh Dev, DCP, he was member of this committee with the police, Ms. SI, Mr. Pankaj Kumar, with the help of Mr. Kawaljit Arora, who was also member of the committee. We, Mr. Gautam Manan, we all sat together and then arrived at got the FastDAR completed, got all the settlements. The offer came fast. The GIC played a very proactive role. And on the 8th of May, we had a pre-lok adalat sitting, and finally on 10th of May, the lok adalat sat, and a settlement was arrived at for 32 lakh rupees. We have a small check, copy of the check, which is available here for everybody to see. So this is how we were able to do. And we have agreed that it is not, we will be checking every fatal case, but we will not be covering every fatal case unless these 5 conditions are available, which will facilitate the faster part. Now, before parting, let me take this opportunity, as I shared, that we are also causing a disruption here by using digital technology in legal in motor accident claims. Morth has done wonderful work. Now, under the aegis of Ministry of Home Affairs, which is controlling the CCTNS, it is known as Crime and Criminal Tracking Network, the MHA along with NIC on our directions have created a EDAR national dashboard. which provides that as and when an FIR under 304A or for that matter 337 and 338 IPC is registered, a parallel dashboard, a template of DAR will be created, and the fields which are available in the FIR will be pre-filled there. And then the other columns which are required, which needs verification of license, the verification of RC, the verification of insurance. All the APIs have been created and tested during this project, which is in the development stage. So I'm sharing this because once this is actually put into production, this will reduce the investigation part time to only 20% of what we are using now. IIBI through GIC was very cooperative. IRDA also cooperated. Now we have mapped Sarathi and Vahan with the CCTNS. All these inputs are there available with us, and we are able to do the verification once it is put in production. And then it will make the entire process paperless. There is another important development which is known as IRAD, Indian Road Accident Database, whereby Amorth has created a cloud software, cloud storage, where the accidents, the spots, videos, the pictures and other things will be stored in the cloud. They will also be mapped, and once the digital DAR is created, we will request the E-Committee of Hon'ble Supreme Court for using this e-DAR as for making the functionality of the motor accident claims in a paperless way, and also with an aim to use AI tools in the future for faster assessment of claims. Now, these are the benefits. Once an entry is done, it will not be required to be repeated any time during the whole process. It will save time and resources. Like Delhi being a cosmopolitan city, we have drivers and vehicles and residents from all nook and corner of the country. Be it a driving license of Nagaland or Kerala or for J&K, it can be done within seconds. So same thing applies with all other remaining documents. So this will be a path-breaking disruption which will expedite the investigation. So I think this is the end of the presentation. May I now request My Lord Justice Midha to throw more light on, because My Lord has been the source of inspiration and guidance to us. Thank you, Lordship. Thank you, everyone.
Thank you very much, Rathi sir.
I think before I take over, I think it would be appropriate for the introduction of all the people here to be given. So
yes, my lord, I will take just a few moments for that.
Yes,
so we need not want to lose the momentum going. So it is appropriate, Your Lordship. There would be a slight change in our agenda. So we want Your Lordship to take it forward. So before that, I just want to introduce Your Lordship. So Justice J.R. Midha is an exceptional personality that everybody knows this. His Lordship is well known for his very active and learned judge of the Delhi High Court since 2006. He has initiated various judicial reforms and written numerous books on CPC and motor accident claims reference. Prior to joining the judicial service, his Lordship was the standing counsel for Delhi NCT Delhi. Elected twice as a member executive of the High Court Bar Association. Justice Midha also a teaching faculty at a campus law center, Faculty of Law, Delhi University. His Lordship done a mammoth amount of work in the field of motor accident claims and also devised a timely payment for the adequate compensation to the victims of the motor accident claims tribunals. We admire his persistence and perseverance in implementing the DAR and now the FastDAR. His vision has not fulfilled within a day. Overcoming all odd circumstances over a years, his dream has come into the reality. Rajesh Tyagi, a case alone will speak a volume about him. We are so proud of you, Your Lordship, for this great event. We feel you are the right person to lead this program by sharing your vision and its implementation. Over to Your Lordship. Thank you.
Mr. Durairaj, I think before you give the introduction of all the speakers here, so that then in between we will not stop, then we will have a continuation, then I will moderate and give a background and then also continue with the speaker. So please give and I think start with Justice Raveendran. He is our chief guest here and he is the main founder of this jurisprudence. So, so that the viewers will have a clear idea of all the speakers here, and then we'll continue. Briefly, you can give it.
So at this juncture, I would borrow the words of our Chief Justice of India to introduce our chief guest here, Justice R.V. Raveendran. He never tried to make an attempt to protect himself as a savior of judicial process. He continued to be humble and believed that office which he did not exist for himself. That alone speaks a volume, my lords. So no words to explain. Yeah, he started a humble beginning in Karnataka and rose up to the Supreme Court. And he is, for Jayaprakash, because of his initiatives, your lordship even appreciated wherever the time permits, wherever the occasion comes. So he made a roadmap for us and for your lordship particularly. So we are so honored to have Justice Raveendran here as our chief guest. And also we have 6 eminent persons here, my lordship, from various sectors as stakeholders here, right from our CEO and MD, Mr. Tapan Singhal from Bajaj Allianz General Insurance Company. He is not only the founder member of the Bajaj Allianz. He's been as an MD for over 9 years. Tapan sir has built the organization to where it is today with a close to the customers of 11 crores. A wide distribution network spanning across more than 1,000 locations across the country. With this, the company has been organized as one of the best in Asia. An avid social media influencer, Tapan sir has over 6 lakhs followers in LinkedIn and has been recognized as the LinkedIn top voice of the India, both in year 2018 and 2019. He is also a chairperson of the CIA National Committee on Insurance and Pensions. He has also been honored as a Personality of the Year, Insurance Summit and Awards in 2019, and 22nd Asia Insurance Industry Award in 2018, and Indian Insurance Summit 2017, and Most Promising Business Leader of Asia at the Economic Times Global Business Summit in 2018. He also won the Best CEO of the Year, honored at the prestigious 3rd Annual Insurance India Summit and Award 2018, and the Insurance Asia Award. So I would like to invite our CEO as one of the 6 eminent person, and next to Mr. Shri Atul Shahai, Chairman of General Insurance Council. Since 2008, he is holding the position as a Chairman and Managing Director of New India Assurance Company. He is holding a General Manager in Oriental Insurance Company, and he was served there also. Now he is holding the good office as a Chairman, General Council. And again, next to that, Mrs. Alamelu, T.L. Alamelu, she is a member of Non-Life IRDA. Joined the general insurance industry in the year 1983 as a direct recruitment officer in New India Assurance. She rose to the extent of a general manager in United India Insurance Company, and then director and general manager of the New India Insurance. And then she rose to the chairperson of Agricultural Insurance India. And 2019 at present, she is holding as a member Non-Life Insurance Regulatory and Development Authority. We welcome you, ma'am. And next, Dr. Padanchali Dev Nair is a regional advisor, Asia Pacific for World Health Organization. He is joined in the industry in 1983 as a doctor and a New India Assurance Company. He is a medical by profession. 2012 and 2016, he was a general manager in United India. And 2018 in New India Assurance. Sorry, there's some disconnect. And he was actually holding in the various positions across India and the globe. And now he is holding the regional advisor, Asia Pacific, and for the World Health Organization. And introducing to the Sanjay Singh, Special Commissioner of Police, is an energetic, young, and very tough and gentleman, and who's behind all the works, whatever been requested by the judiciary on time. He is a key person in the Delhi who is executing the judicial orders, especially the DAR procedures. Sir, we would like to welcome you. And next to sir, Mr. Arora Kennelwal Arora ji is a member secretary of DSLA. He is an eminent person and he is dedicated his life for the judiciary, and very tremendous and approachable person for each and every time. And he is very interested and dedicated for the judicial services, especially the out-of-court settlements. And his contribution, especially for the legal service authorities, is immeasurable. and lot many cases which was a litigations which never could have settled it before the court of law was settled before his presence, and he made himself voluntarily contributed those cases for the amicable settlement. Sir, we welcome you all for this wonderful evening. My lord, I have given the introductions. My lord, it's over to you, my lord. So the dais is yours, and we are awaiting for your wonderful input and for the insight.
Honorable Justice Raveendran, my mentor and the founder of this MSc to Jurisprudence, and all the speakers here on the dais, and all the viewers and listeners. First of all, I'll thank GIC and Bajaj Allianz for organizing this event to celebrate the beginning of a pilot project. Now, before we come to the pilot project, I'll give a brief history as to how we have reached here. It was not a short journey. It spans over 12 years. On 1st January 2009, I, for the first time, came on the roster of motor accident appeals. When I came on the roster of motor accident appeals, I found that the victim of the road accident, whether it is an injury case or a death case, he has to file a case before Motor Accident Claims Tribunal. And there the lifespan of the case is approximately 5 to 10 years. First of all, initial 1 or 2 years notices are not served, then witnesses don't come, then there are other delays. Now, two things inspired me to think further. First was that a person known to me had gone to Canada. When he went there, he met with a road accident and he suffered injury and was admitted in a hospital. The police came on the spot, and from their handheld device, they found out which is the insurance company. They intimated the insurance company, and within 1 hour, the officer of the insurance company reached the hospital. He recorded the statement of the medical superintendent that approximately $5,000 will be spent on the treatment. He prepared a check of 6,000 and said, "Sir, this is without prejudice. You please accept it. If your expenses exceed 5,000, you can come back to us." So within 1 hour, the person got the money. So I always wondered that if something can be done like this, if the insurance company reaches on spot and verifies the things, matter can be resolved. And more particularly in a death case where we have to only find out 3 things: what is the age, what is the income, and how many family members. Now, second incident which inspired me, this was again in 2009. There was a delegation of judges from UK who came to Delhi High Court, and I asked one of the judges, I said, "What is the law for motor accident claims in your country?" So he got surprised. He said, "There's no law. There's an accident. Insurance will verify and assess the loss and pay the money. Whatever 1% people who are not satisfied, they can go to the civil court." Like it happens here in non-motor accident claims. For example, there's a loss or damage. So there's no law. The money is paid by insurance straight away. People who are not satisfied, they can go to civil court or to the consumer court. So then I was quite, you can say, disturbed that with the figures, we had at that time 6 lakh accidents in a year, out of which 1.5 lakh deaths, meaning thereby 1 accident every minute, 1 death 3.5 minutes. So I constituted a committee of Secretary Law, Secretary Insurance, Police Commissioner, all the 17, there were 17 companies at that time, all the stakeholders. I said, "You please come up with a procedure where within 90 to 120 days the money can be paid." So that committee did a wonderful work. They said if within 30 days the police, instead of filing a simple accident information report, if they can give us a detailed accident report by taking into consideration other factors which are there for compensation, then 30 days the insurance will give the response, and 30 days the award can be passed and money will come within 30 days. So there was reluctance on the part of the police to take up the responsibility of detailed accident report. But then finally, on the suggestion of the court, without prejudice, on a trial basis, as a pilot project like we are doing it today, they said we'll do it for 6 months. but the entire institution will remain obliged and grateful. Justice Raveendran was hearing the matter of Jayaprakash at that time, and we had the occasion to share this judgment at Bhopal Judicial Academy. So Justice Raveendran laid down the law in Article 142 that henceforth police will collect all this material and file detailed accident report. So after that Jayaprakash judgment, the police then gave a statement that now since the Supreme Court has laid down the law, we agree to do it permanently. So this scheme of 90 to 120 days started on 2nd April 2010. In the first 1.5 years, there were 21,000 accidents, out of which 11,000 got the money within 90 to 120 days. But then we found, and then at a later stage, then the Supreme Court said this should be applied all over the country. Then we found that our own scheme had some shortcomings. Formats were not there. Then we improved, and in second stage, after about 2 or 3 years after doing research, we prepared the formats of detailed accident report, response of the insurance, and all other formats we prepared. That scheme, then the stage came Rajesh Tyagi 2, Rajesh Tyagi 3. Finally, then when the Supreme Court constituted a committee, that why this is not being implemented all over the country. So DGPs of all the states of India were called by the Supreme Court committee, and they said that this matter will be simplified. In the meantime, there was some amendment. So finally on 8th January, we further modified and simplified the scheme. And now under that scheme, all the cases in Delhi, they are resolved within 6 months of the accident, unless there is some contested issue on which evidence is required, in which case the matter will go to 9 months to 1 year. That is the outer limit. Now, for the last 5 or 6 years, in the Rajesh Tyagi matter itself, I had been taking up the matter with all the insurance companies and stakeholders that where a person has died on the spot, and if we are able to call the insurance company there on the spot, when the dead body is lying there, witnesses are there, and the insurance company can satisfy that, look, the person has died. They can see with their own eyes. Before them, the cremation takes place. Family members are there who are there along with the body. At that time, when they produce the documents of age, income, and number of family members, there's no time for any fabrication or anything. True documents come there. So the calculation can be done there and then, like in the Canada example. Why can't we do it? So this we started for the last 5 years. Finally, 2019 is the first order when this order came, when we proposed that please do it like this. But there was a lot of, I won't say resistance, but the people didn't have a belief. Nobody believed. They said, no, it cannot be done. It is not possible. It is not possible. Finally, this court said, all right, in 2019, all right, as a pilot project on a trial basis, on the suggestion of the court, just do it in respect of 4 police stations of Delhi. So finally, they all agreed, and 8th January, we passed the order that on a trial basis, let's this pilot project start, and 5 conditions should be satisfied when there is a death on the spot, number 1. Number 2, negligence is clear. Number 3, proper driving license. Number 4, valid insurance policy. Number 5, no violation such as drunken driving or fitness or permit or minor driving. So if these 5 conditions are satisfied, then the insurance will verify there on the spot, and we can decide the case and pay the money before the 13th day ceremony of the deceased. So this scheme was launched on 1st May in Delhi. And on 1st May itself, in the morning 4 o'clock, a person was coming from the hospital, his family member or some relative was in the hospital in COVID. So he probably fell asleep while driving and hit the police barricade, and the constable died on the spot. So we immediately contacted GIC. Vehicle was insured with Bajaj Allianz. They were very prompt and they came on the spot. Everything was seen with their own eyes. Negligence was clear. Valid insurance was there. Driving license was there. There was no violation of anything. So within 5 days, the police filed the detailed accident report, which was treated as a claim petition. Insurance company gave the response within 2 days. Motor Accident Claims Tribunal, DSLSA, Mr. Arora, Mr. Rathi, they took up the matter with the tribunal. The tribunal held a special sitting and recorded that, and insurance was very fair. They offered 32 lakh rupees, which was payable in accordance with law. So there was no compromise on the quality of justice which we are doing. And within 2 days, the award was passed. 10th May was the award. 12th May, the money was deposited. and on 13th May, the money was released. So this is a, I would call it a success story to the extent that one case we have been able to do it. But this is just a beginning. Like the beginning we did in the special scheme of 90 to 120 days. We brought down from 10 years to 120 days in 2009. That also we started as a pilot project. But that pilot project and first case we handed over to Justice Raveendran, who blessed the child, and that child has now grown. Today, and we have first case which we are now handing over to Justice Raveendran to bless the child and guide us how we should take it further. You see, one case doesn't mean the end. It is the beginning. So therefore, all the stakeholders will have to work. We'll find some more difficulties. We will find some more roadblocks. We may have to improve this scheme further. We may have to put some more conditions. But the good part is that all the stakeholders are today present here and they are very excited. They are very happy and something good has happened for the country. So therefore, I have now given you the background, how we have traveled this for the last 12 years. And we have today reached a stage where one case we have done. And to that case, it is a complete justice. Although the number of cases are very high, 6 lakh, kindly see the practical effect. 6 lakh accidents, meaning thereby 6 lakh cases in claims tribunal. So in 5 years, it is 30 lakhs. How many judges would be required to decide 30 lakh cases? And 30 lakh cases means 5 family members. So 1.5 crore people being affected. And we have so many other roadblocks. 60% vehicles uninsured, 20% people hit and run, they run away. Those people don't get any money. Today we are only dealing with those cases. We'll take up at a separate forum as to how to deal with the menace of uninsured vehicles, how to deal with hit and run cases. But today we are only where the insurance is there. And fortunately, all the insurance companies are today before us and they all are looking forward for this scheme to mature and for something good to happen for the society. And I will also tell you that in every case which I have decided on MSCT, whenever the victim comes, before releasing the money, I examine the person. I ask the family how they are sustaining. And I found out that in majority of cases, people of upper middle class also, their level comes down to below middle class. The widow starts cleaning the houses. The relatives only support for a few moments. Therefore, it is education stops. They find very difficult to sustain on the planet. So therefore, money is required in a death case immediately. In one of the cases, there was a poor laborer who died. And that laborer, the family was staying in somewhere in Bihar, Darbhanga. So after 4 or 5 years, the tribunal passed an award, which was challenged by insurance company and the matter was stayed subject to deposit. So money was deposited, but nothing was released. When finally the matter came before me and decided the appeal and dismissed the appeal, then we issued notice to the claimant that please come and take the money. So despite service, they won't come. Then we issued notice to the DCP there that please tell those people to come and collect the money. They said, we have lost faith in the system. We came here 10 times to Delhi after taking loan, which we have not been able to return. So we will never go. We are sure we will not get anything. Finally, we requested the branch manager of the insurance company that you please go and give the money there. So kindly see the situation. Most of the people who are dying are poor people on the road. They have nothing to sustain on this planet. Education stops. Their livelihood stops. And if we have to give them the money after 5 years, 10 years, is it a justice? To my mind, it is not. So I will today with this remarks, I will request Justice Raveendran to give us a guide map that how we should take this pilot project, this beginning to the end like we have done it earlier, and please guide us. And also then I will put to each of the stakeholders under what Justice Raveendran guides us that how they should take up their role, because you see in every accident case, first role is of the police. If for example, this pilot project, if within 5 days they don't do it, matter collapses. If they do it, then the ball comes, then the insurance should be called there at the first moment. Because insurance should see from his own eyes that, look, this is the dead body lying, this is the vehicle in accidental condition, this is how the accident has occurred, this is the eyewitness. They will talk to the eyewitness there and satisfy it is a rash and negligent driving. So, insurance should be called at the very first stage when the intimation comes, a person is dying, dead body is lying. To my mind, unless we call the insurance there, they will not be satisfied. Therefore, they are right in saying that we want to be satisfied. Therefore, here we have created a special cell of GIC. Whenever there is an accident, before the IO moves to the spot, he will inform that cell that, look, there is an accident, please come there. So that by the time he reaches the spot and dead body is there, insurance is already there like it happened here. So therefore, not taking much time and waiting, we all are waiting for Justice Raveendran to give us a roadmap and guide map and inspire all the stakeholders here that how we should take this scheme further so that it becomes a regular feature, it spreads all over the country, and the people who are dying, they get the money within a short time. Thank you very much. And Justice Raveendran, please guide us. And you are the founder of this scheme building which we have created. You are the founder. Otherwise, that order which started on 2nd April 2010 was only for 6 months. After 6 months, it would have closed. And nobody today would have known that this thing could have happened. So the whole nation is grateful to you. Whole nation is obliged to you for the great service we have done to the country. And I would also say that in Rajesh Tyagi, we have passed over 200 orders in the last 12 years. The last of 8th January 2021, we have taken into consideration all best practices all over the world and then developed a format, and this scheme is now the best in the world. Thank you very much, and over to Justice Raveendran. Sir, your mic is off, sir. Please unmute yourself.
Thank you, Mr. Justice Midha. Thank you for this opportunity to participate in this great function. You see, you gave the roadmap from 2009 to 2021. Let me go back. Let me give the historical background that brought you to the 2009 situation. All of you know that before MACT, we will call it as the pre-MACT era, suits had to be filed. Imagine the breadwinner. Normally, it is the breadwinner of the family who dies, most of the cases. Breadwinner dies, widow, children, they do not know what to do. Their everyday survival becomes a problem. In this background, they had to collect the police documents and file a suit. They filed a suit, sometimes paying a court fee, sometimes borrowing, and the suit would go on for ages, because even service of the owner, the driver, mostly, you see, what happens is when the accident happens, the driver leaves the services of the owner and goes away. To trace him, it was difficult. Owner, driver, and the insurer had to be served, which took anything between 6 months to 2 to 3 years. Then getting the documents from police, it was a huge job. I know, I was a practicing lawyer. I knew how difficult it was to get the sketch, to get the mahzar, to get the FIR, because you had to produce them. That was a big thing. Then finding the witnesses. You imagine, accidents happen on the highways. Accident happen during night. There will be no eyewitnesses. And you see, the accident would have happened 100 miles away or 500 miles away from the place where the family resides. How will they get an eyewitness? Getting the eyewitness was a nightmare. Proving the income was a nightmare. So getting the documents, proving the death was due to negligence, income, everything was a trauma. added to the trauma of the death of the person. So, as Justice Midha pointed out, and before that, Mr. Rathi pointed out, the cases were taking 5 to 6 years, and then, of course, the compensation, if it was not sufficient, you have to go to appeal. In the High Court, it would take another 4 or 5 years, then Supreme Court. Then, you see, you get the amount in small bits and pieces, and you would have borrowed money for your survival. You have to pay to the lawyer. Virtually, the amount that came was being spent away for the litigation itself. Therefore, whenever there was an accident and death, it was a great tragedy for and trauma for the entire family. It is in this background, the state thought something should be done, and it amended the Motor Vehicles Act and introduced a chapter dealing with motor accidents claims tribunal, in the hope that constitution of the Motor Accidents Claims Tribunal will quicken the process of justice delivery to either the victim or victim's family if the person had died in the accident. But unfortunately, the fact that motor accident cases, motor accidents tribunals were constituted did not give relief to the parties. If it was taking 5 years in original suits before the constitution of MACTs, even after the constitution of the tribunals, it was taking 5 to 6 years. And people had the same difficulties of getting documents, getting oral evidence, eyewitnesses, and proving the case. Now, it is in this background the judiciary became proactive and tried to help the people. What did it do? You see, the monumental change, the first change I would refer to is came up in what is known as Kausnama Begum's case. With one judgment, what the court did was it shifted the burden of proof from the family of the injured or a family of the deceased or the injured to the driver and the owner of the vehicle. How did it do? There was a very famous principle which stated, that is known as the Ryland versus Fletcher principle. If you have a dangerous thing and if it escapes and harms somebody, you are responsible. A strict liability principle was brought in Ryland Fletcher about 1.5 centuries back. Now that principle was adopted, and in Kausnama Begum, Supreme Court said, why should the injured and the deceased family prove? Let the driver and owner prove that the accident happened because of the negligence of the person injured himself, or due to some act of God or some such thing. So let them prove that they were not responsible. So this change made it possible, even though that judgment was in Kausnama Begum was rendered, it was not accepted in some of the subsequent Supreme Court judgments. By following that judgment and by applying the principle of res ipsa loquitur, courts reduce the burden of proving the negligence on the part of the driver. This reduced 25% to 50% of the burden in the cases. Then what happened was, each motor accident claim tribunal had their own philosophy of awarding compensation. You used to get such a difference. You used to for the same type of accident, one would give 1 lakh of rupees, another would give 10 lakhs of rupees, another will give nothing. They were taking a strict view and saying that there was the negligence was proved. This kind of thing was happening. Then in 3 cases, Supreme Court moderated and regulated the entire matter. That is in what is known as Susama Thomas first by Justice Venkatachalaya, and in Trilok Chandra, I think by Justice Ahmadi, and later by me in Sarala Varma. We kind of stabilized the calculation of compensation. As Justice Midha pointed out, we brought it down to only 3 factors. What is the age, what is the income, and how many members of the family. we created a formula so that the compensation could be easily calculated. In fact, the formula became so standardized that without the help of courts, without a decision by court in Lok Adalats, the insurance companies would come with their calculation on the basis of the judgment. Yes, this is the amount payable, we are willing to pay. Now, that ensured that the calculation of compensation became easy. So, the proving the accident and liability, proving the liability became easy, calculation became easy. And in fact, Supreme Court in some other cases went and gave further relief. They found that some cases there was insurance, but there was a violation of the insurance conditions, and therefore insurance was made not being made liable. In a series of cases, Supreme Court said, no, nothing doing. You give the money, you give the amount, compensation, and then recover it from the owner. Though this was created a lot of problems for insurance, they are doing it, and even now it is doing it. So the procedural problems in regard to proof of the accident, negligence, compensation, accounting, and all these aspects were standardized and made easy. But unfortunately, what Justice Midha found at that stage was, even with all this, nothing could be, the problems continued because the time factor. It was taking 4 years, it was taking 5 years, it was taking more, and there was no way the people can get compensation. That's how he started this crusade. I would say it is a crusade started by him. He did, what he did was, passed innumerable orders. He just now told you, he has passed 200 orders. I remember this. In leaders, you have what is known as doers and preachers. There are people, some people who are wonderful teachers or preachers. They will say how to do, everything will be planned. But you ask them to do something, they will not be able to do anything. And they are doers who do not have the imagination to have a scheme, to formulate a scheme, but they will be able to execute it if somebody says, you do it in this manner. But there are very few people who are good preachers and doers. And Midha belongs to that extraordinary category of small percentage of people who can think, who can formulate the scheme and execute the scheme. Otherwise, normally judges are all preachers. Let me share. They are preachers. They are not doers. They will say, you are wrong. You are right. You do this way. That's all. They have never done it. Of course, in the PILs, some judges are trying to do something, but nobody has done it with the tenacity shown by Midha by closely following the matter for 12 years, passing 200 orders, constituting committees, turning the screws. And I know how difficult it is to make the administration, the executive, to come round and quicken the process, because they have their bottlenecks, they have their red tape, they are answerable to audits. Therefore, they are reluctant. But he ensured that by constant supervision, constant guidance, and even a little cajoling, a little threatening, he got it to a stage where he proved to the country that it can be done. See, what the stage where we are is not that all the cases for compensation claims are going to be decided in 10 days. No, sorry. The type of cases where the compensation can be given in 10 or 12 days or 15 days or even 1 month are extraordinary type of cases which constitute hardly 1 to 2% of the total number of motor accident cases. That is, there should be a death, the valid license should be there, valid permit should be there, valid insurance should be there, there would be no violation of insurance conditions. I mean, you get only 1 or 2%. But what is important is, in those 1 or 2% cases, if you make a beginning and show that things can be done in 15 days or 1 month, it is easy, it is possible that even in the other type of cases where a longer complicated issues are there, they can be decided. If not within 15 days, you can do it in 3 months, in 6 months, and 12 months, and not 5 years or 10 years. This is the achievement shown by the effort of Justice Midha. Not only his effort, again, he can only pass orders, he can only call officers, but it requires the cooperation, and the cooperation extended by the police, extended by the insurance companies, extended by the judges of the motor accidents claims tribunals is extraordinary. Without their cooperation, he could not have done it. And it has been a great success in Delhi. And Justice Midha did it in Delhi High Court. I think Justice Prakash did it in the Madras High Court. But in several other states, it has not yet taken off. It is still to be taken off. But you see, the experience gained by the insurance companies, experience of the police, that can be shared in the other states also to ensure that the process can be quickened. That is where you see the Justice Midha can hold the hand and show the way only to that extent, so long as he is in service and so long the case comes up before him. Thereafter, it is for the other stakeholders to take up. To the baton has been passed. You can consider today is the day when Justice Midha is passing the baton to the police, to the insurance companies, to the MACT presiding officers to continue the good work, to continue the good work and ensure that the motor accidents claims are settled as quickly as possible. And the great injustice that is happening, the great harm that is happening to the families of the persons who die in accidents is the aggravated problems are solved and they get their compensation. It is, in fact, in that context, it is a special day. There is absolutely no doubt it is a special day. But let us not, rest on our laurels. One day, deciding one case and giving compensation in one case is not giving compensation in 5 lakhs cases that are being filed every year. This should be continued. They should be done on a war footing to ensure that the compensation cases are decided early. You see, it is not sufficient. You see, we are still ashamed. You see, the figures have been given. Imagine 5 lakhs cases accident. 4.5 lakhs is the figures that are being given. And in India, a lot of cases are not reported. That also happens. Therefore, it is of the order of 5 lakhs cases. If we have 1% of the vehicles in the entire world, but our accidents are 11%, it is something to be ashamed of. Our road safety measures will have to be improved. Our roads have to be improved. One side, we should prevent accidents. The other side, when there is an accident, there should be an immediate cure, in the sense the minimum pain and suffering is caused to the families or the victims. If we can do this pincer movement, one side, reduce the accidents by road safety measures, and on the other side, compensate the victims in a manner that their trauma is minimized, we will be doing some service to the society. Otherwise, we will all be only talking and postponing the decision and passing the buck, and it will become one more file. That's all. That is not what it should be. The service should be extended. First, you have extended to this type of cases where there are no dispute. Next, you should extend it to other type of cases where a time factor is even 6 months or 12 months, and try to reduce that time frame. And even the complicated cases, disputed cases, are settled in 3 or 4 months. That should be the goal. I am sure with the kind of beginning we have made, with the kind of forms and the scheme that has been put in place, it will become easier to take it forward and give relief to others. Of course, there will be hitches. The scheme will require frequent modifications, and the formats will require more simplification. From time to time, the forms will have to be modified and reviewed and made simpler. And at the same time, when you are quickening the process, you should ensure that there is no fabrication of documents, no false claims, fake claims, and that this quickening the process does not become a tool for the unworthy and the people who want to cheat and make false claims to come forward with false claims. You should ensure that there are no false claims. At the same time, you should ensure that the claims, genuine claims, are decided early. I'm sure this effort, which has begun in the year 2009, when the journey was started by Justice Midha, and with his 200 orders, with the various schemes, modified schemes, which have been repeatedly approved by the Supreme Court and accepted by the Supreme Court, and now followed in other states. For example, in Madras, it has taken root. I am sure that other states will also follow suit, and the stakeholders will extend cooperation for all other states also, and the motor accidents tribunals in those states, to ensure that compensation is distributed to the victims and their families at the earliest. Thank you.
Thank you, Justice Raveendran. It was a very enlightening and inspiring discourse to all of us, and we will certainly follow the guidelines and the roadmap shown by you. Before we proceed further, Justice Raveendran, we have got the victims, namely Shakti Singh, who is the son, and Vimla Devi, who is